Welcome everyone to the January meeting of the Judicial Branch's Access to Justice Commission. It's a little bit after 2 o'clock, 2:04, so we're going to get started. I noticed that in addition to the people in the room appearing remotely, Roseanne Rush, Tim Sheeran, Patrick, PJ Geek, Ed Heath, Moy Ogilvy, yes, we've had Dawn, Valley, Sandra Ginez, Walt, and Judge Spader, Jamie Bell. So and Judge Stewart. So thank you all for appearing today. We have the first item on the agenda is the review and approval of the minutes. They were circulated to everybody prior to the meeting. Is there a motion to approve the minutes? Judge Daniela, is there a second? Second from Judge Shukla. Any discussion regarding the minutes? Seeing none, all those in favor of approving the minutes say aye. Aye. Any opposed? Any abstentions? Okay, so thank you. That's out of the way. The next item on the agenda was going to be a presentation by Dean Galini about licensure reform work. We're going to push that back because we're trying to work out some technical issues with that. So we'll move instead to the updates from the subcommittees. We'll start with the pro bono subcommittee and Judge Stewart.
To figure out how to unmute myself. All right, so as you might have seen from or been reminded of if you reviewed the minutes, when I last presented, we had identified basically issues of demand and supply. And since our last big group meeting here, our group has met at least twice. And by the end of that second meeting, we had put everyone in our committee on one of two working groups, and I myself am going to be in both of them. One of those groups, first of all, on the demand piece, we're going to wait for the Connecticut Bar Foundation to finish its work, which I understand will likely be this summer before we work on that piece. But on the supply piece, we've got two working groups. The first of those is to work to develop a one-stop, probably website for both would-be clients and would-be attorneys, and I suppose also paralegals, to access, to find out what opportunities there are, first of all, for the clients, obviously, to be represented or get help in a particular area, and for the legal providers, the lawyers and the paralegals, what opportunities there would be for them to provide pro bono assistance. We want to make this so that it's very easy for everyone to access, very easy for the agencies and the legal aid groups and so on to be able to post things. So that group will be working on that. The other working group is going to be arranging for what I would call listening tours and interviews of the kinds of people we think are invested in pro bono and would be interested in helping us, primarily to stay on the positive side. In other words, how to get more lawyers to volunteer to do pro bono work, and to get those who do volunteer to do more work in terms of both volume and the, increase the types of things that they do. So, we have, a lot of survey information from the past that have identified the pretty obvious hurdles there are, and we'll listen to some of that, but the emphasis will try to be on the positive. So once I get my head out of a couple of trials here, I'm going to be arranging for both of those groups to get working. So that's and the notion is it would be, iterative. In other words, we'd work separately in these groups and then periodically come back together, because I'm sure, for example, those of us who are doing the interviews and listening tours are going to find out information, I hope, that would help the people designing the one-stop site. So that's our plan.
Does anyone have any questions? So I just want to add that for those of us who have been involved in this for a while, the one-stop shopping idea is something we had started with back in 2011, and we came up with the Pro Bono portal and ctlawhelp.org. And I think the idea is that over time, there are probably enhancements that can be made to that. I know that other groups have, the Bar Association has done some of its own work in that area, and to try to get as much of that combined as possible to the extent it makes sense to combine it and make it even easier for people to navigate. And the hope, I think, is that the listening tours will gather information about what's currently missing from the resources we have that we can improve and streamline to make it easier for everyone to use.
Yes.
So we're building off of what we've done in the past and not just kind of reinventing the wheel. It's the idea. All right, thank you, Judge Stewart. So next is the self-represented access to justice issues subcommittee. Judge DeMille.
So we're following some potential pilot programs that really focus on bridging the gap. In particular, at least 3 different areas. And when thinking about these issues, we decided that we would focus in on housing specifically versus trying to sort of cast the net too wide. And so we're focused on housing and try to come up with some pilot programs that work. Focusing on the knowledge gap and sort of underneath that, the plain language is one of our important processes. I know that there are small claims already has one, so likely working internally, maybe working with the National Center for State Courts to create some a process that might work better than some of the language that we tend to use in the profession. The availability of court advocates. Can we revitalize lawyer per day? Can we use volunteers to come in and help folks get through the process? Technology gap. Our court service centers and public information desks are amazing, and they likely do provide some services, but how can we look beyond that in terms of not only court advocates who might be able to help from a different perspective, not necessarily lawyers, but perhaps folks who are far more adept at technology than I might be, and how we might use our local resources, whether law schools or libraries, and to help bridge that gap and give those folks opportunities to have access to technology if they're not comfortable doing so in the courthouse. In terms of the access gap, bringing courts to the communities, what are the access to courts, what are the pressure points where folks can't get there. We do a good job in case flow requests and allowing people to appear remotely, but what are the other ways in which folks can get to our courts that we're not using? So we're exploring all kinds of areas and opportunities for individuals who don't have access in the ways in which they may need and we might like. Zach Zarno is going to join our next meeting, which is next week, 22nd at 1 o'clock. So he's going to focus in on some of these areas and help folks move forward.
So with the focus on housing, have you discussed how this would either work with or separate from the right to counsel program in housing matters?
Yeah, I'm hoping that we start having those conversations. The last meeting we decided to focus on housing. Then the holiday meeting sort of happened and we didn't move much forward. We'll meet with Zach, and we have some folks obviously on our committee, and including attorneys Bell and Shay who are involved in that process, as well as others. And we'll start having those conversations.
Don't have any questions for Judge Stepiola? Anyone else from the committee want to add anything? Thank you. The next is the legal aid subcommittee, Judge Thomas.
Good afternoon, everyone. So we have our next meeting set for January 24th. We have invited Angela Schlingheim, who's the executive director of the Bar Foundation, to present us on 3 issues, one of which is the status of various right counsel programs in Connecticut, and that one or both would be for the legislature in this legislative session, and that new report's been issued by Scouts as to the outcomes achieved by that program. So she'll present us on that. Probably to duplicate other committees. She's also going to present us on the state of the legal needs study and where that is. And then finally, we're going to talk about kind of the landscape of legal services in Connecticut. Ariane and I continue to collect resources and information on geographic area services, what's available, where the perhaps legal aid services are not readily available. And then we have a couple of other topics that we're going to explore with Judge Bright after today's meeting for future discussion. Additionally, to that, just looking forward, I think, like to find ways in which we can collaborate both with the Access Committee and the Pro Bono Subcommittee, just to make sure that we're supplementing efforts and probably working in combination to get efforts. So I'll try to have those conversations after today's meeting.
Thanks. Anybody questions, comments?
That next meeting you mentioned sounds super interesting. Would that be something that's open to everyone in the commission or just me?
Would you like to
I would like to, yeah. Thanks.
send you January 24th? That's okay.
I mean, that's a very good point, Jen. I would encourage anybody, if you hear something that a subcommittee is working on and you're on a different subcommittee, there's no reason why you can't attend that other subcommittee's meeting. And it may be that if you're on another subcommittee and you see this kind of cross-fertilization that can take place, you talk among yourselves about having, whether it's a joint meeting or a small group of a meeting of members of those subcommittees kind of getting together and just talking about things you may want to do together. Okay. And the fourth is the Law Library Law School Subcommittee, Judge Spader.
He may not be on.
Okay, yes, he had a docket this afternoon, so he had a summary that he sent you, right?
Yep. So on behalf of Judge Spader, while I planned on attending and tried to lighten my docket for today, I have a few cases remaining for after the lunch break and will be on the bench when this meeting occurs. I will try to log in if I am able to, but I strongly feel part of access to justice is making court dates meaningful, and I have self-represented litigants right now working with court staff to make presentations to me, and they requested the extra time of the lunch break to be fully prepared. And while the cases may resolve with everyone's assistance, and ultimately I may not need to hear a fully contested matter, my availability to help the parties resolve their cases pulls me away from being able to attend. The Law Library's Law School Subcommittee met in late November and meets again next week and has been generating ideas and assessing needs and had fruitful conversations about current services provided by our law schools and law libraries. We are meeting again next week with some updates from our law librarians on the committee, and we are looking forward to hopefully generate some real action items for our conference next January.
Thank you. All right, so that's everything from the subcommittees. Unless there's other thoughts anyone has on the various subcommittees. Seeing none, then I think we are now ready for Ian Galini's presentation on the licensure reform work, which has access to justice components to it, both in terms of number of lawyers, and I'll talk about some other stuff that other states are doing with respect to licensure to address access to justice issues. Right?
I need hold music.
Okay. Yep.
If anyone who is remotely has anything to say, just unmute yourself and talk because we can't see you, unfortunately.
Start a slideshow.
Yeah.
You have them again. Yes.
Yeah. And do you mind putting it in there? Thank you, Judge, and thank you all for your patience. I'm going to chat with you a little bit about the intersection between, really candidly, the bar exam and access to justice. So I'm going to kind of go in this roadmap. I'll talk to you a little bit about the bar exam itself, the landscape of our profession as it relates to the number of attorneys, both nationally and in Connecticut, the states that have thought about reform, as Judge Bright mentioned, and then I'm going to actually make a pretty big picture proposal and close by suggesting that really my proposal maybe isn't as big because reform of the exam really is sort of the norm. So off we go. First, the bar exam. So just a tiny bit of history. So the bar exam started in 1880, and it was when New Hampshire created its first central repository. And if you fast forward by 1931, almost every state had an exam, and the NCBE, one of the more critical players in our story, was formed. And their goal was to create something of a uniform approach to the exam. And indeed, by 1958, that momentum was sort of up and running. And by 1972, as we get into some familiarity perhaps from this group, the multi-state bar, the MBE, was formed. And by 1988, the NCBE added what is also, I suspect, familiar to the group, the MEEE, and our familiar subjects, often called the Big Six, around Civ Pro, corporations, wills, trusts, states, crim law, crim pro. But what a lot of people don't realize is that there's considerable troubling history behind the bar exam, and that in many spaces the bar exam was designed to keep people of color and immigrants out of the legal profession. And I chose one of many examples. South Carolina, for example, would grant diploma privilege to law
Excuse me,
graduates.
Dean, I'm sorry to interrupt. I don't know if you can hear me, but if your presentation's on screen, it's at least not showing up on my team's screen. You might have to stop sharing and reshare, but maybe that's just my screen is stuck.
No, I appreciate you saying something. I wouldn't.
We were just looking at your Outlook screen. There you go. Now it's up.
That
Thank
did
you.
it. Terrific. Yep. Oh, perfect. Okay, so we're back to South Carolina, that until 1886 would grant diploma privilege to law school graduates, but then changed the law. The law changed such that diploma privilege was available only to all-white University of South Carolina. And now I've lost the ability to advance the slides. This is fun. Well, this will be awkward, but you know what happens as Dean, you sort of get used to any room and any presentation format. So, all right, we'll work with it. By 1950, South Carolina was forced to open a separate law school for Black students, and the legislature would introduce legislation that, quote, was designed to bar Negroes and some undesirable whites from the legal profession. For its part, Connecticut, there we go, gave its first exam in 1890 and included general competency in the exam, which was designed to keep those who didn't have a formal education outside of the profession. As we fast forward to today's exam, what's the most common? It's the uniform bar exam, the one that we give here in Connecticut. It has three components: 200 question multiple choice section, the MBE, the MEE around essays, and then the MPT. That one, that's I lost the ability.
Yeah.
It's okay. I'm OCD with it. I haven't said it. Sure. I'm good. Yes, but that is I'm good. I promise. So the second day of the exam has both the MEE, the essay, and then the MPT, this idea of a file-based, we give it to candidates to respond to a simulated problem. And the National Conference of Bar Examiners is the one who administers it, a private, not-for-profit, based in Madison, Wisconsin, sort of the irony of all ironies being the diploma privileged state. It is not a member-regulated entity. It is not actually answerable to anyone in the government. And the UBE itself is the result of a decades-long push from the NCB to give a uniform exam. And despite being a nonprofit, ostensibly, it reported $168 million in assets in FY24. So how much does it cost to sit for the exam in Connecticut? So I estimate a single sitting at $29,000. So my breakdown is an $800 fee to register. By the way, that's early. $125 if you want to use a laptop and not write. Travel and lodging for the day of, to stay near the conference center. Bar study and class materials, $4,000. And then people like me will tell students one of the most important empirical reasons people fail the exam is because they work, so don't work. And because so many graduates, not just of Quinnipiac, but of all law schools, have jobs that are contingent upon bars passage, they have to wait also for scoring, because remember, this is an exam given just twice a year. So living expenses accrue, and that's where my entirety of cost comes from. However, what people rarely realize is that the cost of the exam is not actually financeable in student loans. But act now and you can get what is now called a bar loan. There are entire banking industries that have popped up that will give you what are often predatory loan rates in order to finance that $29,000. So if we're going to charge $29,000, at least we could have a uniform exam, uniform scoring. But as this map reflects, in the orange, which you're looking at, the jurisdictions that have adopted the UBE, and the blue boxes are the jurisdictions that have given what's called a cut score. So the UBE is out of 400. You'll see us off to the right with a 266. I was lucky enough to be the dean of Willamette University College of Law in Oregon for 4 years, where if you look off to the left, my graduates had a cut score of a 270. So if I got a 268, did I pass or did I fail? Well, it depends, because for first time taker rates, you'll be able to tell you that I failed. But if someone were to say, you know, Dean, I got a 268 at Willamette, but what I'd like to do is join you at Quinnipiac. You can what's called port your score to Connecticut, and I can register that student without ever having taken the exam again as a pass for what's called ultimate bar pass purposes. And that's what it takes to keep a law school's doors open and lights on. The ultimate bar pass standard is that all graduates who sit for the exam must 75% of them pass the exam within that 2-year period. This idea of score porting complies with that without, again, ever having passed the exam the second time. Now, the current bar exam, although it's been around for more than a century, a recent seminal study in 2020 revealed that although it's been around for quite some time, there's never actually been an agreed upon evidence-based definition of minimum competence. So we've got a costly exam with disparate scoring, and part of the reason there's been difficulty in identifying what minimum competence is that closed book exams offer a poor measure of practice, time constraints, similarly distort what we ask new lawyers to do. I'm glad you're sitting down for the next one. Multiple choice questions bear little resemblance to the practice of law, but the multi-state performance test, this MPT, does in fact resemble some of the things that we expect from newly licensed lawyers. Now, in the summer of 2020, to add on to the state of the profession, the ABA released long promised data around the demographics of the exam to reveal what many scholars already knew, which is that the bar exam produces racially disparate results. And I pulled that data for you and highlighted just 2 illustrative examples there in yellow. Bar takers who look like me passed at a rate of 93%, whereas by contrast, bar takers of color, there's a roughly 15% differential in pass rates. So let's hold that brief lesson on the bar exam and talk about the access to justice component, starting at a really big picture lens at the national level. So there are 1,300 counties in the US who have fewer than 1 lawyer per 1,000. That means 40% of all counties and county equivalents in the US. Part of the reason, of course, is the salary gap. The wage for entry-level salaries is $63,000 for lawyers of public court interest, orgs, $59,000 for public defenders, and $57,000 for lawyers in civil services. The other issue is law school enrollment, which has changed dramatically. The numbers speak for themselves. In 2010, there were about 147,000 JD students. Fast forward to 2022, there are just 116,000. Likewise, the applicant pool has gone down. There were 100,000 plus applicants in 2004, and there are now 62,000 applicants. Amid a lower lower enrollment and applicant pool and lower bar pass rates. So in 2008, the national average was 82%. It has now dropped to 72%. So the idea that there's a cavalry coming up from behind is categorically false. Moreover, there is the pandemic. Whereas nationally, 1/3 of lawyers, 33% entirely of those age 62 and over, said that the pandemic changed their retirement plans. And within that cohort, half of them said that it hastened their retirement plans. Meanwhile, unemployment trends, good news for new law graduates, continue to go down. In fact, they're some of the lowest that they've ever been. However, those new law graduates are selecting private practice at rates higher than ever at 52% overall. So for all of those reasons, perhaps not surprisingly, the access to justice gap has gotten bigger, not smaller. And the Legal Services Corporation in a recent report said that a staggering 92% of low-income Americans face their civil legal issues without counsel. But what about in Connecticut? Well, as this group knows, there's 3 ways that we've sort of attacked this question. But before we do, some numbers about us. In 2023, there were about 21,000 attorneys for 3.6 million citizens, which is about 5.8 attorneys per 1,000. Within those numbers, the 9.8% poverty rate would allow for 3.5 legal aid lawyers for every 10,000 people, but that the poverty rate rose 40% between 21 and 22 due to the expiration of a number of federal COVID programs. And by last year in 2024, Connecticut's attorney population had fallen to 18,000 attorneys, and its loss of more than 3,000 attorneys was the single largest attorney decrease for any state in the entire country. Now, the 3 ways we've sort of attacked this is: one, you're sitting here, you know this one. The second one is the 2016 Access to Justice Task Force, and the previously already mentioned, although we should have coordinated beforehand, 2021 legislation around civil rights counsel for defendants facing eviction offense. So I went back and did a little research on this commission and looked and met for the first time in 2011. The first iteration I sort of categorized as from 2011 to 2024. During that 13-year period, the commission would meet for a total of 26 times, taking multiple 1-year breaks along the way and sort of fits and starts. It would produce a first annual report with 16 recommendations in October of 2012, and then there was no further action I could find in the meeting minutes after that report, nor were there further annual reports. There was, however, a modest means work group that I saw in the minutes that launched an incubator program out of UConn that ran until 2017, that, as far as I can tell, has since closed. Other work groups, of course, existed, pushing initiatives like access to video conferencing, strengthening pro bono, raising awareness of the public library resources, and the connection to the court system. The second piece is the 2016 Access to Justice, Access to Legal Counsel in Civil Matters, which had a really precise charge to look at the unmet civil legal needs of Connecticut residents. And it made 3 key findings publicly available in the court. First, that unrepresented litigants were common in certain types of family law cases, that 51% of consumer law collection cases contain at least one non-appearing defendant. And third, the absence of the right to counsel threatened Connecticut's housing stability. And so it made 3 recommendations: that there exists a right to counsel, and that third one, which was ultimately adopted, the defense of residential evictions. That leads us here. So in 2021, Connecticut became the second state in the country to launch the statewide right to counsel program. It began by offering services to 15 different zip codes, and across those zip codes, eviction filings post-COVID, after the moratorium was lifted, has increased by 14%, and in one particular zip code increased by 40%, and in all other zip codes increased by 10%. We now have some data, having the report produced by the CBF come out on a year-over-year basis, that renters with counsel would receive a ruling of 45% positive ruling in their favor, 45% of cases, compared to 27% without. The 12% of renters were represented by a lawyer post-RTC, up from 7%, which of course was an increase in right to counsel zip codes, but the staffing challenges were quite real. The program launched with 20 lawyers. It was ultimately doubled to 40. But by November of 22, the finding was that the goal was to disseminate this right across the state. We would need 100 full-time lawyers for the right to counsel program. And right to counsel attorneys report being overwhelmed by the number of cases, and that if a program doesn't have capacity, it shuts down until a sufficient number of cases are cleared. It's reasonable to ask, before we turn to and hang with me, I'm almost done with my proposal, where are all the graduates going? Where are the graduates? Connecticut's law schools, but what about the other law schools who come and sit for our bar exam? So I looked at that too. So pre-pandemic, the bar pass rates are consistent to some degree with the national trends we already looked at, fall on the pre-pandemic rate with 487 FTT, just stands for first-time takers. I was at 78%, and it has now fallen to 75%. Though note the higher number of first-time takers. The bar pass rates across all schools, i.e. all those who would come outside of Connecticut law schools and sit for the exam, but tell a similar, though slightly more pronounced story. The pre-pandemic bar pass rates were higher with a lower number of takers, and now we have a higher number of takers, but a lower bar pass rate. In total, I thought you could think about this in terms of potential lost labor workforce. A total of 306 graduates didn't pass in the pre-pandemic period. 216 didn't pass during the pandemic, and then 342 haven't passed the exam since the post-pandemic period. What's interesting is to juxtapose those numbers against the national trends around public interest. So the interest in public service has gone up. The data shows us in Connecticut's law schools. Pre-pandemic graduates were interested in 7.4% of graduating classes, pandemic up to 8.6%, and then at a high of 12.5%. I got interested in whether that trend matched the national, and it does. 7.5% has grown nationally to 9.45%. And the growth, according to the National Association of Law Placement, that this has surged over the last several years and is now at record levels. So what's the bottom line? Here's your pro. There's a growing interest for new law graduates practicing public interest, growing interest in new law graduates practicing in Connecticut. And we have a civil Gideon. Here's your con. We have nationally leading declining attorney population, a declining post-pandemic first-time taker rate, and the access justice gaps increasing, not decreasing. So here's a thought on reform. In 2020, a number of states concerned with kind of the areas that I've outlined here, the absence of mental competence, the absence of an exam related to attorney skills, racial disparity in bar pass rates, the cost of the exam, and that we're not closing access to justice gap, started to really think differently about licensure. As that conversation happened, the ABA, that for 103 years has supported a bar exam, said, states, you should really consider something other than the exam as a mechanism for licensing. These are now the states that in no particular order have, as that momentum has continued, grown from a reform standpoint. And I thought you might be interested in hearing just a couple of the most relevant to our group, but there are themes that you're detecting across all of the states engaged in this work have tried to address some mechanism to lower costs, to eliminate the racial disparities, tie licensure assessments to skills, to ground those assessment and learning theory, and to address some of the legal deserts in our country. So just a couple of examples. South Dakota put a committee together that in 2023, by the way, just 2.2 lawyers, lower than ours for every 1,000 residents, that put together a recommendation for a public service pathway. And the idea is that 10 graduates from the University of South Dakota's law school would complete a set curriculum, including completion of externships, and then engage with a practicing attorney for at least 2 years in the public interest. Post-graduation, received a lot of positive conceptual feedback and sits on the desk of the South Dakota Supreme Court. Most recently in 2024, Arizona has taken a slightly different tack. It created and in fact launched the Arizona Law Defense Program. It requires candidates to sit for the exam, stay with me on this one, fail the exam, their cut score is 270, but they must earn a score of 260 to between 260 and 269, which PS is a passing score in their neighboring states, that awkwardness aside. In addition to getting that eligible UBE score, they are assigned to employment with an eligible employer. They complete a 24-month supervisory period and a set number of hours to work, and then they are licensed to practice in Arizona. There is also in Oregon, the launch of the Oregon Supervised Practice Examination, which it was my pleasure and privilege to work on for 4 total years. I was lucky enough to appear in front of the Oregon State Supreme Court across that period for 6 different periods of time, and the SPPE became available to candidates in May of 2024. So what is it? Graduates complete 675 hours of supervised practice with a qualifying supervising attorney. Those 675 hours, the committee chose because they're the average length of time someone would spend sitting for the bar exam. 100 of those hours can be earned while a graduate, or rather a student, is in an externship or in a clinical law program. And then candidates for licensure, in addition to the hours requirement, submit a portfolio of work, 8 total pieces of attorney work product, 3 of which must be at least 1,500 words long. And the same board of bar examiners that grades the exam grades the portfolio. That's just the back of the envelope. There's a lot more to it, but it needs your revenue. How's it going? There's some data now. It launched in May of 2024. So as of June 10, there were 47 candidates who applied, 62 attorneys, 57 different employers applied to supervise. As the summer wore on, those numbers grew to more than 100 applicants. And those applicants, by the way, are unique, i.e. those who are the equivalent of first-time takers, folks who chose to pursue this path and not pursue the bar exam. So who are the employers? They're public defenders, they're DAs, they're legislative counsel, they're large firms, Nike, state courts, and some smaller firms and nonprofits. Finally, you might be interested because it sets up the CLEAR committee work from the National State Courts. Scholars during the pandemic proposed the Lawyers Justice Corps. It's this idea that public service organizations would hire new law graduates through their normal career process, and immediately after law school, graduates who would work for that public interest group, they would not sit for the bar exam. And there would be a 6-month provisional period, and candidates similar to the SPPE would submit portfolios for grading as appointed by the state's board of bar exams. So all of that is now packaged in front of the CLEAR committee, which this commission has heard just a little bit about already. It was established in 2023. It's comprised of 9 state Supreme Court justices, 3 state court administrators, and is set to deliver recommendations around licensure coming up. One of those recommendations, bullet 3, is that jurisdictions adopt pilot programs following the model of the Lawyer Justice Corps. So my proposal is that aligning the SPPE with the Lawyer Justice Corps offers a really attractive foundation for this commission to think about, particularly given the early success of the SPPE addressing some of the access to justice challenges in Connecticut. So here's my proposal, that this commission work on creating a pathway that is designed to strengthen access to justice in Connecticut. There would be a pilot program attached to Civil Gideon because we have what so few states have, which is pre-existing legislation, and that applicants to the pathway, which could begin with the pilot, complete a set curriculum in law school, engage in a set number of hours to supervise practice, and submit for review to the Connecticut Board of Bar Examining Committee proof of their work product done during their tenant eviction defense. I'll just close by saying, for as radical as it may seem to some, reform really is the norm in the licensure space. I pulled the very first, I don't expect you to read this, don't worry, there won't be a test. This is the very first ever bar exam in Connecticut. So when someone says, well, you got to have a bar exam, they don't mean this bar exam. And that's because the exam has been changing. And it's changing right now. Here in Connecticut in 2026, the NCBE has said we will have the launch of the what's called next gen bar exam. You can ignore those other points. The point is the exam is shifting around. Connecticut is an early adopter. And here's the map. In blue, those are the jurisdictions that have adopted next gen. In gray, those that haven't. I just want you to leave with the understanding that, for again, as different thinking as this might be, this is a really complex landscape for our graduates to function in. Connecticut will launch next gen in 2026, but I don't see a lot of other blue around our state. Vermont is blue, but they won't administer next gen until 2028. Just yesterday, New York announced it will adopt next gen, but it won't go until 2028. So there's already a lot happening that's disruptive in the licensure space. My suggestion is that we do it for the benefit of Connecticut.
So we can put the people on the screen back up so we can see them for their hands above. See if people have questions for Brian or comments on any of this. I'll start, Brian. I just had a few questions. The first, kind of from a historic perspective, how do states determine the passing score? Why is it that it's 270 and
Yeah, my Oregon grads
260
dramatically superior to. Yeah. Well, the short answer, and I don't mean to be glib about it, is depends. I mean, so I presented to Alaska a couple of years ago. They were a 280 cut score, and when I presented to the board, I asked them, "Why do you have a 280? It's the highest cut score in the country." And they said, "Well, because we thought 280 out of 400 was a passing score in law school." So can I articulate to you, or can anyone articulate to you the difference between the 270 and the 266? That should concern us.
Yeah, and I guess the other question I had about if you do a program like Arizona does, do you then create kind of a second class
Yes.
group of,
I don't support, nor do I propose following Arizona. I think it exacerbates the racial disparity and may dramatically exacerbate that disparity by not just creating tier 2, but sending a really dangerous message about the importance of access to justice along the way. So I shared it with the commission in the interest of updates, but that is not what I propose.
and you familiar with the Noah Webster?
The Daniel Webster.
Daniel,
Yeah, very familiar.
Daniel Webster, if you could talk a little bit about that.
Yeah, I didn't talk about that one, but so happy to talk about it. So UNH, more than 10 years ago now, launched the Daniel Webster Scholars Program, which is a litigation track to licensure in state. The idea is that you complete a curriculum in law school, you have a summit of experience that's experiential before you graduate, and you earn a license to practice in New Hampshire. The data on that program are extraordinary. The results have been tremendous. And in visiting with Dean Carpenter, who's the dean at UNH, in doing this work, she'll say that I can't keep enough of them even here in New Hampshire because other firms will call and say, do you have any Webster scholars for me? There's a lot of benefit to that, and maybe more time or granular than folks are interested in this discussion, but to stand up and run a program like that at the law school level and make it scalable, it's called an honors program. So their cohorts are about 12 per class. That won't make a dent of the sort that I think we need to make a dent in this room. Moreover, because it's honors, it's not a good standing program. And at least my thought is that if you're in good standing to sit for the bar, you should be in good standing for the right to counsel.
So if you're thinking then of a more broad-based program, how many students, and I don't know whether you can tell this from what's occurred in other states or what you would project, would be interested in pursuing this alternative pathway as opposed to doing the traditional pathway, taking bars?
So one of the hard lessons that I've learned, two things on that is one, and it's like hindsight being what it is. I sat on the first conceptual task force in Connecticut that was called the Alternatives to Exam Task Force. I should have flagged at the beginning, you never should have called it an alternative because people think of it as less than. That's why I pitched today as licensure reform, because it lets the current exam off the hook. They get to create their own alternative, but no one calls them on it. So that's sort of point one, licensure reform. I think two, what I've learned is that we have to capture the interest of graduates early. And the reason that I bolded that 100 hours of clinical externship work can be earned in law school is that's where you can hook graduates. So in my own community and in other law school communities, those who pursue externships or clinics, by the way, almost 100% of today's graduates do, if they're told that the clinic or externship that they're passionate about will also earn them credit toward licensure, doing the sort of high impact work that brought them to law school to begin with, that's how I think we book them.
Does anyone else have? Yeah.
Well, so this is a good way to encourage people to work for nonprofits, such as Legal Aid, hoping to close the gap that way. When these people are accredited or licensed, how do you think the response is going to be from other employers, law firms, judicial, that sort of thing? And are we just creating, being blind, are we just creating a class of legal aid lawyers, which is good, but what else is going to happen here?
I would say roughly three things. I mean, this is the exact and good, thoughtful question that we spent a lot of time on in Oregon. But one of the reasons I wanted to show you the data on the results is that for all of the folks who are, the world's coming to an end, we have to have bar exam. Those folks are sort of decreasing, and the participation levels are increasing from not just public service organizations. So that's sort of point one. Point two, I think there's a lot to be learned from Wisconsin or what it's been doing. Pure diploma privilege, where discipline rates are no different. What we learned about data and discipline rates is that they happen to experienced lawyers, but they don't happen the differential rates in Wisconsin to those that have a bar exam. And then point three, there's no asterisk in Oregon, Wisconsin, or New Hampshire for the license that those graduates earn. So, well, that's one of the most important things, that people just care ultimately that you're licensed and that you have the skills.
If I could just ask, we have Roy and Tim and Ed and Tanya, who have all been involved in large law firm management, about what their reaction would be to a candidate, an associate candidate who didn't take the bar exam, but has spent a year or two working in public interest after earning their diploma through a program like this. Roy, you want to start on it?
You're putting me on the spot. I mean,
Oh, you unmuted first.
can you hear me?
Yeah.
Yeah, you're putting me on the spot. So, I mean, I don't know what our response would be. I mean, to the extent that there is an approved program that's vetted, I would suspect that we would be open to it. I know it obviously that doesn't exist yet, but I mean, if there's a program that's set up and it's going to be, seen as the equivalent of getting good practical experiences those years, I would think that we would take those candidates like we would take any other candidate. But I mean, again, we haven't been presented with this in any of our regions yet, but it's probably only a matter of time.
Ed?
Yeah, I mean, I can't say anything officially on behalf of the firm, but I can tell you that we're always looking to have a diverse class of incoming associates. And so this would be another way to have that diversified class. I'm sure it's something we'd be open to considering. It wouldn't, I think most importantly, what I'd say is it wouldn't be, I doubt that it would be an immediate no. We'd see that and say, we can't consider that person. I'm sure we'd consider the applicant like any other.
Tim, you have anything you want to add on that?
Actually, Judge, I think I can probably speak for all of us, and not to denigrate the law schools, but some of the first-year associates coming out don't have any experience whatsoever, even in the practical areas of law. So to the extent we're trading up with somebody who's got some feet on the ground experience, it actually might give them an edge. But I'm like Roy and Ed, we'd have to wait to see how those candidates look and what their experience truly has been.
Yeah, my initial reaction is the same as Tim's, which is, obviously in court we see a whole range of level of quality of attorneys who all have the same note that they passed the bar exam. So having people who have gone through a program where now have gained experience, I think would be viewed as judges as beneficial, I would say. Any other questions for Brian on this?
Just question about
this.
I don't have a question.
Go ahead, Tanya.
Sorry, I'm in the car, so I can't see anybody. But
Sure.
I don't have a question. I just have a comment. I mean, I echo all of those sentiments. I also think, needing the practical experience is really, really important. And so to me, that would be really attractive to get that. I'm not speaking on behalf of the firm, but wouldn't that give the leg up for everybody?
Yeah. Thanks. I think a lot of us feel that way. I do, but Cecil, you were gonna.
So if you could, I have two questions. One is, you talked about this aligning with the eviction rent council program. And so I just wondered if you could walk through. So I'm a third-year law student. I'm about to graduate, considering what path to take, taking the bar exam. What are my options? So that's question. And then my second question would be just how does this align with ongoing discussions or possible discussions around kind of revisiting the third year of school? So having 2 years of kind of theoretical, teaching you how to think, evidence, federal tax, all of that, those fun topics. But then having your third year will be placed somewhere. Just interested in your thoughts on.
Yeah, I think comment one, or graduates I could imagine graduates doing both. In other words, pursuing the Connecticut Right to Counsel pathway. Then they join a firm and the firm says, we'd like you to have a portable score. So they sit for the bar exam. So I think really having both of those options so they can go where their career takes them is actually really important.
So just to be clear, so at the point of graduation, you're not sitting for the bar exam.
Correct. That's true. Yeah. I mean, in this space, you're producing graduates who they literally walk across the graduation stage on a Monday and they are starting work on a Tuesday. And off they go. So that speaks to the practical experience comment. And they're producing work product that again would be graded by the Board of Bar Examiners, the same folks who are grading the essays already. To point two, I think it is aligned with, you know, in sort of Galini's world of like, what does that third year look like? It should be heavily experiential, which is why I think it's so valuable that some set number of hours can hook into an externship or a clinic. So you get the double benefit of I'm getting academic credit. In an emerging number of law schools now, I can be paid for my externship and I can be paid in my supervised practice placement. So instead of paying to take the exam, I can earn income while I'm contributing to the needs of the state.
And so, sorry,
No, please.
but under this model, so then it presumes that there's an employer available
Market
on the
driven,
other side.
100%.
Who can,
So
and the reason I make the observation is that when I started in 06 and graduated, there were jobs. And then for 12 years, 10 years, there were jobs and new services. And now there's a fair amount of opportunity in large part because of, I think, federal funding and other things that have expanded the opportunities of these programs, including the council.
no, 100%. If everyone was like, great idea, but you go do you, and nobody would take a provisional licensee, then the licensure system falls on its face. That's an unequivocal truth. I think that starting with a pilot to prove, to your question, to prove the quality of the graduate who emerges from these programs for the benefit of the entirety of the state, I think that the bar exam is a controversial topic. I've sat hundreds of hours of these conversations. And for many states, like, yeah, we get it. Like, we just need to attack the thing. Oregon, for its part, had an extreme criminal defense crisis. It's like, just give us skilled graduates in rural areas like yesterday. And the ability to prove that those graduates can perform at a high level was enough for that list of other employers to come out of the woodwork. But that didn't happen by kind of throwing the gates open necessarily at the outset. So doing something really strategically focused on access to justice with a pilot core that we can track the outcomes and disseminate them across to the balance of the state to prove how, going back to the 2016 report, maybe the next step is child custody. Maybe it's consumer protection. Maybe as we think ahead a couple of years, it's about immigration representation. I left out of this presentation, we're one of the lowest immigration representation states in the country. So there are opportunities for this to move into those particular pathways.
Thank you.
That's so thank you. I have a question, not about the reform, but the tie into access to justice. So I guess my question is, even under this pilot program, where is the funding coming from? So like you mentioned the public defender's office or here, the right to counsel. So where is that coming from under this model?
So what we saw and what we continue to see in Oregon is it's a couple of different places. So place one, I sort of think about Connecticut Right to Counsel as analogous to what Oregon has in universal representation for immigration. So that's a state-funded state statute that provides universal representation to those with an immigration issue. And the charge was through state funding, a particular set of nonprofits to execute that. Those folks hired provisional licensees. So the state is one answer. The second answer is that we increasingly saw employers recast, literally from a granular HR perspective, attorney vacancies into provisional licensee vacancies. So we would see, for example, public defenders, prosecutors, we saw it in the mid and smaller firms say, well, we're not going to hire entry-level attorneys. We're going to hire provisional licensees. And in the rules, the details that I didn't get into in this presentation, because the rules require that the employer pay at a rate consistent with newly licensed lawyers and incentivized the participating employers to stand up those HR positions consistent with the same pay they would pay entry levels, and then fold the licensee into that entry level position afterward.
Anyone
I've
else?
got a question.
Yeah, go ahead, Diane.
So I'm still thinking about the question that was posed to us. And so my question would be, are there any studies where we've looked at whether passing the bar is indicative of whether or not someone will be a good attorney? And I heard you talk about, discipline rates, but I was almost thinking of like the SAT. Like, is the SAT really a good barometer of how successful one might be?
No, it's a great question. And there's some really, including recently, 2023, Bloomberg put out what I think is the most comprehensive assessment of employers' satisfaction with new law graduates. And one of the biggest complaints is that they might be talented, in terms of their ability to think, but they're not ready to practice law. And that's the biggest sort of legal education gets conflated with the incentives legal education has, which is to pass a bar exam. So you've got to sit in my role. My job is to set up a curriculum that helps a student pass the exam, but that's not, to the point of the Bloomberg survey, what employers want. Employers and judges want talented graduates who understand skills. So the 2020 study I cited called Building a Better Bar Exam talked about standing up a broader base assessment around attorney licensure skills, but not talking about them as like someone who has the skills of a 30-year practitioner, but NLLs, newly licensed lawyers. What do we want from a skill set standpoint of someone who just walked across the graduation stage? So those, I think, are the most predictive, and right now it doesn't exist. That's why employers are so grumpy. But those are the sort of predictive things that we can think about through a program like this. It's assessing skills, not multiple choice or closed book testing.
Anyone else have any comments, questions? So I think that this is a really interesting area. It was something that was discussed quite a bit at the National Access to Justice meeting I went to in the end of October. A lot of states are looking at it. I think that it seems to me, Brian, that there has to be a conversation with our bar examining committee and kind of trying to find some common ground if there's an interest, as you said, they've just decided to do the next gen piece of this. So now are they going to be interested in further reforms? But I think that's a conversation that's worth having. And there are some possibilities for funding that I'm thinking a little bit about. One is the Client Security Fund. Each year, if it has more money than it needs to deal with attorney defalcation issues, that money gets redirected to legal aid. And it seems like there's some nice mix between the Client Security Fund that is taking care of bad practices by lawyers now maybe happening to fund a program like this. It's been now that the amount of available funds depends on how much is paid out in any given year to pay for lawyer defalcations or other issues, but that might be one source of funding as well. But if you're interested in working more on this for our commission and maybe kind of working with the bar examining committee and with Brian and others, please shoot me an email, shoot Nicole an email, and we can kind of put together a small ad hoc working group. Judge Elgo on the appellate court is on the bar examining committee, and I see her every day, so I'm sure we can kind of set something up and continue the discussion. All right. Okay, so that was a very good presentation, and I think it's something that coming into the Access to Justice Commission I hadn't really thought about doing, but it's I think something we should need to think about. All right, now I want to provide a brief summary from the national meeting that I went to in October. As I said, one of the things that was talked about quite a bit was these licensing reforms, not only in the area of all reforms to the bar exam, and I think a lot of states were very concerned about the second-class citizen issue that I discussed, and that's why programs like the Daniel Webster program was so interesting to me and to other people, where not only was it they not viewed as second-class citizens, but it was like, geez, this is really a great program that makes lawyers or new grads even better prepared to practice. But there was also quite a bit of talk about licensure reform to license paraprofessionals to provide services that right now people can't afford to pay lawyers to do. I think Connecticut is now a minority in states that require lawyers to do real estate closings, for example. So there is a push in other states, Texas being one of them, to license paraprofessionals to do a lot of things that we presently require lawyers to. The Washington Supreme Court a number of years ago adopted a rule that would license paraprofessionals to do a number of things. I've had conversations over the years with lawyers, and lawyers are understandably concerned about something like that and how it might affect their practice. I kind of think of it like nurse practitioners, PAs in the medical profession. The medical profession has figured out really well how to make money off of those paraprofessionals, and I think smart lawyers would figure out the same thing. So it is something that we may want to think about, and I'm not sure particularly what subcommittee that fits well into, but I would suggest that any subcommittee that thinks that might work, whether it's legal aid, whether it's self-rep access to justice, give it some thought, maybe kick it around at one of your subcommittee meetings. The other thing that was discussed at the meetings, which I hadn't really thought about, and I think we should think about, and I'd like input from people, if you know people would fall into this category. A number of states have non-lawyers on their commissions. And the idea is we all look at things from what we can do as lawyers, but we never really look at it from the user standpoint. What do users need to see, or where are they running into the problems? And we depend on Court Service Center people who tell us this is what we're hearing from people. But there may be, whether it's community organizers or non-lawyers who are in the community who are trying to help people navigate those legal issues. And I think it may make sense to add one or more persons like that to our commission so we can get that perspective where they come in and say, you know, you guys are talking about a lot of great things and this sounds really interesting, but this is what we really need. So if you have an idea of somebody who you've worked with, either as a lawyer or as a judge or as a court staff person and dealing with people in the community that you would suggest, please let me know. And I'd like to talk to that person or those people and see if we can find a couple of people who would be interested in working with us to provide that connection between the legal view that we all bring to it and the public need part of it. The other part, this is something that I'll need to talk with the Chief Justice and with Judge Bizzuto and Ty Moore, is a number of states have a full-time staff member within the branch devoted to access to justice issues. We have really, really great staff in the judicial branch, but we ask all of them to do more things than we would ask anyone else to ever do. So the question is whether we should have one person who would do that, who would do help make sure that all the work that we're doing is coordinated among the various parts of access to justice. We haven't even really talked a lot about LEP as part of this, because we have a separate LEP group. And then the other thing that a lot of the full-time staff do in other states is they make sure that the community that we're trying to serve know about all of the programs that we have. Not just to, publicize it and make us look good, but to make sure that people know that there are services available to them. We can have websites, we can have online tools, which we have, but if people don't know they're there, the full-time staff in the other states spend a lot of time kind of front-facing, and time that it would be unfair to ask any of you to do, because you all have full-time jobs on top of whatever you're doing for this commission, and you all are involved in other volunteer stuff, because I knew what all you do, and that's why I asked you all to be part of this commission. So I want to have that conversation, but that's a resource conversation. We'll see what we can do there. There were a lot of discussions about pro bono and legal aid. There was some discussion, some states are looking at loan forgiveness programs for law students that go into legal aid. That's one way that you can maybe tie it in with encouraging people to pursue public interest stuff. So it's something that legal aid and pro bono subcommittees may want to look at. Pro bono, and we had talked about doing this a little bit in our pro bono committee, but some states have kind of annual dinners with their chief justice where they give pro bono awards out to lawyers. And I know the CBA does a great job with doing it. But there might be some benefit of combining that with judicial recognition as well. So it's something that's, I think, worth taking a look at. Delaware is using attorney registration fees for legal aid salaries. I don't know where, I just checked off that I'm exempt from paying my occupational tax, but I don't know kind of where our occupational tax goes. I don't know if anyone else does, but it goes into the state somewhere. It just goes to the general fund. So whether it's worth trying to make a pitch that the money from the registration or the annual attorney tax should go to access to justice issues. So those were kind of the big things. There was more. I'm happy to talk to anyone about it. One other thing I did want to mention. There was a lot of focus on debt collection practice. And we've talked about that before, that the default rates on debt collection matters, whether it's small claim or Superior Court, are extraordinarily high as compared to other areas. And a lot of states are focusing on how to reduce those default rates. Some states do not require a defendant to file an answer. You just got to say, I got this complaint, I contest it, and they get to come in and have a hearing instead of trying to figure out what a special defense is, and they come in and tell their story. I was contacted, at the conference, someone who knew these Yale undergrads said you may want to talk to them because they are developing a program to, and they spent a year building this program where it's going to be an online assistance program for people who have questions because they've been sued in a debt collection case. And they're going to do a rollout on January 28th. It's going to be supervised by Yale Law School, but the Yale undergrads are going to be the ones answering the questions, trained. I've met with them and we've talked a little bit about making sure they stay on the right side of the line of not providing legal advice, but providing information. And their rollout on January 28th down at Yale. Chief Justice Mullins and I are going to go to that. If you're interested in going, let me know. I'll get you the information associated with that. So those are kind of the big things that we're working on. Other states are doing plain language. We've talked about doing plain language stuff, and we have the resources here in Connecticut with this National Center for State Courts. So, I think we should continue down that road as well. But it was a good meeting. There was a lot of energy, and there's a lot of stuff that's being done in other states. We always do very well in the grading on how we do on access to justice issues. I'm proud of all the stuff we do, but there's stuff we can learn from other states as well. Things that are worth focusing on. So if you have any questions about that, just let me know. So the last item on our agenda is a discussion of our future Access to Justice Conference. So I asked for volunteers who would be interested in working on the planning for the conference. Judge Rapillo volunteered, so she is now the chair of the planning committee for the conference. We had a initial meeting where we talked about past conferences that we've done, Krista and Nicole and I and Judge Rapillo, and talk about what we might want to do in, now probably about 15, 16 months from now. So Judge Rapillo, I don't know if you want to talk a little bit about that.
Good timing. I've been trying to do a trial in between listening to some of this meeting, so.
Yeah. What I mean about multitasking, so.
So yeah, I mean, the idea is that there would be a conference that would happen in a little over a year's time. As before, the audience would really be to go towards the law firms to try to just attract people to do pro bono work by highlighting all the good work the branch is doing, what's being done in the community. There's also some idea that we should be adding in groups that can really add kind of the constituent voice as an audience in this. We have to talk about that a little bit more. So it's really very early on, but what we're just kind of asking is that as the subcommittees are doing their work, that you start to think about what you're doing or what you've seen that you think would be helpful to be highlighted at this conference, and keep us going. If anyone has ideas or is interested in working on the conference, definitely reach out to me. But it's really just been one meeting to start talking about it. And the idea would be to highlight projects that are being worked on. We had talked possibly about using COVID as a lens to look at it. Like, what did we change through COVID that maybe helped with access to justice or hurt? And what could we do going forward? But really the idea is to highlight good work that's been done, good work that we're planning to do, and try to get the community energized about helping us bring it further. So more to come on that, and please reach out to me if you're interested in helping.
Thank you. So, and again, the idea is that hopefully all of our subcommittees, whether individually or working together, can develop actual things that when we have this conference, we are rolling out, and maybe it's talking about things we've already rolled in. But it's not just discuss what we want to do, but what we are doing and what we've recently done to improve access to justice. So, let's keep kind of working in our subcommittees to come up with concrete ideas and decide what it is we would be proud to show lawyers and residents of the state of Connecticut in, May or June of 2026.
So plenty of time to get ready.
Yes. Be here before we know it. So that's all we have on the agenda. Does anybody have anything else that they would like to talk about?
I just wanted to remind everyone the next meeting is Thursday, April 3rd at 2 p.m.
If between now and then you have ideas on other topics, if you have ideas on something to have a presentation at the commission like we had with Brian today, please let me or Nicole know and we'll get it set up. Great. That's it. Is there a motion to adjourn? Judge Thomas, is there a second? Second, Judge Demiola. Any discussion? All those in favor, say aye. Aye. Any opposed? I want to keep talking. All right. We're adjourned. Thank you, everyone.